the backs of our hands together. It's still wet, so the ink should transfer. Meet me at the side door. We'll sneak on through the main floor. All night, let's take a shot. Keep moving and we won't get caught. Take the long way home. Tonight we're free to roam. Everything's gonna be alright. Just let go, enjoy the ride. To the top of the world tonight. We're never coming down. Never coming down. No, we're never coming down. Never coming down. High on life, got a good buzz going. I've got no way of knowing what tomorrow's gonna bring me. Not gonna worry. Everything's gonna be alright. Just let go, enjoy the ride. To the top of the world tonight. We're never coming down. Never coming down. No, we're never coming down. Never coming High on life, got a good buzz going. I'm never, ever, never coming down. Never coming down. No, we're never coming down. Never coming
Welcome. Excuse me. I had to clear my throat for a second. But today is Judge George Mertz's docket. So let's get started with the Judge Mertz. Make that bigger. Here we go. Yes, I'll be watching, but I will be monitoring. Muted.
Testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yeah.
Ms. Holloway, you understand that by pleading guilty to larceny in a building, that that's a felony that carries with it a maximum penalty of up to 4 years and or a $5,000 fine.
Yeah.
Right, and that by pleading guilty to your probation violation, let's see, Ms. Wagner, what's your underlying charge there?
It's larceny 200 to 1,000, 1 year misdemeanor.
Okay. And the probation violation, your charge there has a maximum penalty of up to 1 year in jail. Do you understand that?
Yeah.
With all those things in mind, what is your plea today here as to both the larceny charge and your probation violation?
Your Honor, just to make it clear, it's an attempted larceny in a building, not a building.
I'm sorry, I missed that. Okay.
That's correct.
So that means I was wrong, Ms. Holloway. The maximum penalty on the attempted larceny is not 4 years, it's 2 years. You understand that?
Yeah.
Do you need more time to talk to your attorney about that, or do you understand that difference?
I understand.
Okay. Does that change anything about your willingness to enter into the plea today? Okay. And you're going to plead guilty to that charge and your probation violation, is that right?
Yeah.
Okay. So you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent or proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you want it. You understand that you have all those rights.
Yes.
On your probation violation, you also have the right to have a hearing on that. You understand that? And that by pleading guilty, you're going to be giving up all of those rights. Has anybody threatened you with anything to get you to give up your rights in this case? Anything other than what we've said here in court today? Your choice is to plead guilty to this charge. You are in fact guilty. The information I have indicates this happened back on February 16th of 2025. Is that the correct date for the larceny? And on that date, did you take some credit cards? Did those credit cards belong to you? Did the person that they belong to give you any permission to take or use those cards? And was it your intent to use those cards for your own purposes, to buy things for yourself? Did that happen here in Kalkaska? As to the attempted larceny charge, Mr. Ziegler?
Ms. Holwood, did that happen inside of the building? In a house? I'm satisfied.
Mr. Seeger?
Yes, sir.
And Mr. Ziegler, would you also agree that Ms. Holwood's testimony as to the larceny charge would form a factual basis for finding that she violated her probation?
Yes, sir.
Mr. Seeger?
Yes, sir.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Seeger?
No, sir.
Mr. Ziegler, are the people satisfied that the court has complied with statute and court law in taking this plea?
Yes, sir.
Mr. Seeger?
Yes, sir.
All right, Ms. Holwick, the court finds that your plea is knowing, voluntary, accurate. Court is satisfied there is a factual basis to support a finding that you are guilty of attempted larceny and that you did violate your probation based on your testimony here. The court will accept your guilty plea as to both. We'll set both of these for a sentencing hearing. You'll be notified of the date and time of that hearing. And Ms. Wagner, will you do a violation report along with the PSI on the new charge?
I can, Your Honor, unless Your Honor is okay with me just doing a verbal on the PV, since she's gonna be facing more time on the felony.
Okay, yeah, actually, I don't think I need a full probation violation report. So if you can just kind of combine the two.
Okay, thank you.
Mr. Ziegler, anything further today?
No, Your Honor.
Mr. Seeger?
No, Your Honor.
Thank you, Ms. Holwick. That's all for today.
I'm sorry, was that an added count?
It'll be an add count 4.
Okay, do you have a pack code for that?
It'll be the same as count 1 with the added bracket. Yeah.
Markovich next. He's lodged in Wexford. That's connected.
Ms. Simpkin is here, I think.
Versus Taylor Simpkin, case number 255034. The record should reflect Ms. Simpkin present here in the courtroom today. And Mr. Seeger, can you tell me the status of this file?
Your Honor, it's my understanding Ms. Simpkin is going to tender a plea to 1 count of possession of narcotics, which would be treated under 7411. Additionally, Your Honor, there's some misdemeanor files that would be dismissed, all traffic related.
So the offer, this plea to count 1, is that correct, Mr. Ziegler?
It is, Your Honor, count 1 with the understanding that it would be treated under 7411.
Okay. Ms. Simpkin, have you had an adequate opportunity to talk to Mr. Seeger about this plea?
Yes.
need any more time to do that before we go. You raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God.
I do, Your Honor.
Thank you. Ms. Simpkins, are you currently on any kind of probation or parole?
No, sir, this is my first violation.
And you understand, so you don't have any kind of prior controlled substance, really?
I have no prior record.
None. Okay. You understand that the maximum penalty you could face for the charge in this case would be up to 4 years and or a $25,000 fine.
I do, Your Honor.
With that in mind, what is your plea to that charge today?
I plead guilty.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you want it. You understand all those rights.
I do, Your Honor.
You understand that you're giving up and waiving all of those rights by pleading guilty.
I do.
You also don't have an automatic right to appeal the plea that you're making here today. The only way you can appeal it would be by leave. That means you have to ask for the next higher court up, the Court of Appeals, to hear your case. They could say no, and then that would be an appeal. Do you understand? Does anyone threaten you with anything? Yes. Has anyone promised you anything other than what we said here in court today?
No, sir.
Is it your own free choice to enter this plea?
Yes.
Are you pleading guilty because you are in fact guilty?
Yes.
The date that I have for this is back in August of 2024, August 26th. Is that the correct date? Yeah.
No,
At that time, were you present here in Kalkaska County?
I was.
While you were here in Kalkaska County at that time, did you have possession of some cocaine?
I had a pipe with presumably cocaine residue inside, yes.
And did you have any legal right to have any amount? Were people satisfied with the factual basis?
Yes, Your Honor.
Mr.
Yes, sir.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
No, Your Honor.
And Mr. Ziegler, are the people satisfied that the court has complied with statutes and courtroom taking this plea?
Yes, Your Honor.
Yes, sir.
Simpkin, the court finds that your plea is knowing, voluntary, accurate, or to satisfy there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. We now and then make sure that you stay in touch with Mr. Seeger, and you're going to meet with the probation department here today to set up a pre-sentence interview before you leave. Mr. Ziegler, anything further on this file today?
No, Your Honor.
Mr. Seeger.
No, Your Honor.
Thank you, Ms. Simpkin. That's all for today.
Your Honor, could I have just a moment? Mr. Parkovich is not available.
Yeah, I don't see him. Terry, can we call a Wexford and see if they're gonna have Mr. Markovich? Just a second on the video.
TJ's in the interim call.
What's that?
TJ's in the interim.
Markovich's?
Yep.
Oh. Does he need help for us though in Antrim?
Yes, sir, that's correct.
All right, let's take a short recess.
Weird, I don't know if that was what happened, but yeah, it shouldn't be.
We're all set.
Perfect. Thank you.
Mr. Lindsay is here.
Okay.
Some things are written, doesn't matter where you go.
All right.
Mr. Seeger, are you ready with Mr. Lindsay?
I am.
Okay. Versus Tyler Lindsay, file number 2557. Should reflect Mr. Lindsay's death.
Your Honor, it's my understanding that the people have offered Mr. Lindsay an opportunity to plead to an attempted malicious destruction of personal property, $1,000 or more, but less than $20,000.
That's correct, Jeff.
Okay. All right, Mr. Lindsay, have you had an adequate opportunity to speak with Mr. Seeger about this plea agreement?
Yes, sir.
You need any more time to do that before we go forward today?
No, sir.
And has he spoken to you about this plea agreement and told you the terms of it?
Yes, sir.
Okay. And what we said here in court today, is that the same agreement that he's spoken to you about before?
Yes, sir.
Is that how you want to proceed today?
Yes, sir.
Did you want to enter a guilty plea to that charge today?
Yes, sir.
Can you raise your right hand, please? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Mr. Lindsay, are you currently on any kind of probation or parole?
I am in Grand Traverse County for a DUI that I got like the same night.
Okay. Are they aware that you're going to be entering a plea in this case here?
Yes, sir.
Okay. Do you know whether you're going to receive any penalties for violating your probation?
As far as I know, there will be no more repercussions.
Okay. And then you understand that by pleading guilty to malicious destruction of personal property as an attempt, that the maximum jail sentence you could face would be up to 2.5 years.
Yes, sir.
With that in mind, what is your plea to that charge? I'm going to go through your rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You can have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand that you have all those rights.
Yes, sir.
You understand that by pleading guilty, you're going to be giving up and waiving all of those rights and you won't have those anymore.
Yes, sir.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it or get it reversed, you would have to ask for the Court of Appeals to hear your case. You don't have to hear your case. They could say no, and then that would be the end of it. Do you understand that?
Yes, sir.
Has anyone threatened you with anything to get you to plead guilty?
Yes, sir.
Has anyone promised you anything other than what we said here in court today?
No, Your Honor.
Is it your own free choice to enter into this plea?
Yes, sir.
Are you pleading guilty because you are in fact guilty?
Yes, sir.
This incident happened the end of September in 2024, is that correct?
Yes, sir.
And at that time, here in Calcasieu County. And did you damage or destroy some property that belonged to Sheila Anderson?
Yes, sir.
What kind of property was that?
I'm not entirely sure, Your Honor. What it,
Household items, those kind of things, or was it a building?
I'm guessing that it would be referring to household items. I'm not entirely sure what the,
Okay, so some kind of personal belongings of Miss Anderson?
yes, sir.
Okay, and did you do that on purpose?
Yes, sir.
Okay. All right, Mr. Ziegler, are the people satisfied with the factual basis?
I'm satisfied. Your Honor.
Yes, Your Honor.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Seeger?
No, sir.
And Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Seeger?
Yes, sir.
Mr. Lindsay, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Make sure that you stay in touch with your attorney prior to that date. And then today you're going to meet with the probation department to set up a pre-sentence interview. Mr. Ziegler, anything further on this file today?
No, Your Honor.
Mr. Seeger?
No, sir.
Thank you, Mr. Lindsay. That's all. Just make sure you talk to Agent Barrett before you leave.
Your Honor, if you're still waiting for Antrim, my other two are here, Mr. Goodrich and Mr. Patrick.
Looks like we have them connected right now. All right, Mr. Barkovich, are you able to hear me okay?
Yes, sir.
And just to confirm for the record, your name is Terry Jordan Barkovich, is that correct?
Yes, sir.
The record should reflect Mr. Barkovich is present today by video from the Antrim County Jail. We have a number of different files set for, I believe, a plea hearing today. Just going to go through those files. It's 255009, 5010, 5011, 5012, 5013, 5014, 5015, and 5016. And Mr. Seeger, it's my understanding that we do have a plea agreement that's going to involve a number of charges in some, but not all of those files. Is that correct?
Correct, Your Honor. Your Honor, the current offer is that Mr. Barkovich complete no time. My understanding, or at least it's reflected in an email that Mr. Ziegler had sent to the court, the police reports, which would be used as the factual basis to a no contest plea. But in any event, Your Honor, it's my understanding that Mr. Barkovich would plead no contest to 4 counts of UDAA as a habitual offender second, 1 count of home invasion third as a habitual offender second. Those are all 7.5-year felonies. And then he would plead to 1 count of escape, which would be with no habitual offender notice, which would be a 4-year felony.
Okay. Mr. Ziegler?
That's all accurate, Your Honor. I would also note that the remaining 4 or 5 files are to be dismissed, including a file that's in district court. But any and all restitution across those files is to be preserved as part of the plea agreement.
Okay, and I just want to make sure we identify for the record which charges apply to which files that he's pleading to.
So in file, I don't have them organized by number, Your Honor, but in file 5012 FC, that file has 1 count of UDAA as a HAB 4. He'll be pleading to UDAA as a HAB 2.
Okay.
In file 5010, charge of UDAA HAB 4, he'll be pleading to UDAA as a HAB 2. File 5009 FC, charge of unlawful driving away, habitual 4, he'll be pleading to unlawful driving away as a habitual 2. File number 5015. Charges in the complaint are home invasion first, unlawful driving away and larceny in a building as a HAB 4. He'd be pleading to home invasion third and add count 4. And count 2, the unlawful driving away, both as a habitual second offender. And then finally, in file 5011 FC, charges escape awaiting trial for felony as a habitual 4. He'd be pleading to count 1 escape with no habitual enhancements.
And what's the maximum on that one?
Your Honor,
4 year?
it's a 4-year escape charge, Your Honor, and it's mandatory consecutive.
Mr. Seeger or Mr. Ziegler, as to the other charges, are any of those either mandatory or discretionary consecutive to each other?
Not in terms of their nature, Your Honor, although I believe he was on parole, if I recall correctly, at the time of the offense, so they would be mandatory consecutive to his parole.
So all of the files?
Correct.
Okay. So they're all mandatory consecutive to the parole, and then the escape is mandatory consecutive to the 4 UDAAs and the home invasion.
That's my belief, Your Honor. Yes.
Okay. Mr. Seeger?
That is correct, Your Honor.
Okay, Mr. Barkovich, were you able to hear all of that?
Yes, sir.
Okay. Have you been able to discuss this with Mr. Seeger prior to today?
Yes.
What you discussed with Mr. Seeger, has that been consistent with or the same as what you've heard here today in terms of the plea agreement?
To the best of my understanding, yes.
Okay. Is there anything that you want to discuss with him before we go over or go through with the plea here today?
No, sir.
All right. And Mr. Ziegler, my understanding is that no contest plea would be based on a lack of memory. Do you have any objection to the no contest plea?
I do not.
Okay. All right. So Mr. Barkovich, can you raise your right hand, please? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You can lower your hand. So Mr. Barkovich, you were on parole at the time that all of these offenses occurred, is that correct?
Yes.
So you understand that your sentence in these files will all have to run consecutive or back to back with any sentence you would receive for violating your parole. Do you understand that?
Yes, sir.
And then do you also understand that you would not be eligible for any jail credit because you were on parole?
Yes, sir.
And you understand that for each of the 4 counts of unlawful driving away of a motor vehicle as a habitual second offender, the maximum penalty you could face for each of those charges would be up to 7.5 years?
Yes, sir.
And that the maximum possible penalty you could face for the home invasion charge would also be up to 7.5 years. Do you understand that?
Yes, sir.
And then finally, the escape charge, the maximum possible penalty as to that charge is up to maximum of up to 4 years. Do you understand that?
Yes, sir.
And then you also understand that your sentence on the escape charge would have to run consecutive to your sentences in the unlawful driving away charges, the home invasion charge, as well as your parole violation. Do you understand that?
Yes.
Is there anything about all the consecutive nature of those sentences? In other words, that they will run back to back? Do you need to discuss that further at all with Mr. Seeger, or do you feel that you understand how that's going to work?
No, I understand how it works.
Okay. With all of that in mind, what is your plea to each of those charges here today?
I believe I'm pleading no contest to those.
Okay. So I want to go through your rights with you because they apply the same whether you're pleading guilty or no contest. So right now you have the right with regard to all of these charges and all of the files. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. You understand all those rights?
Yes, sir.
And you understand that you're giving up and waiving all of those rights by pleading guilty.
Yes.
Also, you don't have an automatic right to appeal the plea that you're making here today. You can only appeal it by leave. That means if you wanted to try to get it reversed or vacated or withdrawn, you would have to ask for the Court of Appeals to hear your case. If they said no, that would be the end of any appeals. You understand that?
Yeah.
Has anyone threatened you with anything to get you to plead no contest?
No.
Has anyone promised you anything other than what you said here in court today?
No, sir.
Is it your own free choice to enter this plea?
Yes, sir.
All right, thank you. I was provided with a number of police reports prior to the hearing today. I did have a chance to review those. I want to identify those for the record. As to the charge in file number 255009, the court is going to refer to Kalkaska County. Kalkaska County report number 244004538 for that charge of UDAA. Mr. Ziegler, have you reviewed that report?
I have.
Do you agree that it would provide a factual basis for the charge in that file?
Yes, Your Honor.
Mr. Seeger.
Likewise, Your Honor.
With regard, court will mark and admit that report as court exhibit 1 in file 255009. To file number 255010, also a charge of UDAA. The court's referring to Michigan State Police report number 722488-24. Mr. Ziegler, have you reviewed that report?
I have, Your Honor.
Would you agree that that would provide a factual basis?
I do, Your Honor.
Mr. Seeger.
Likewise, Your Honor.
The court will admit, mark and admit that as court exhibit 1 and file number 5010 as a factual basis. In file number 255011, that is the escape charge. The court's referring to Kalkaska County report number 244004578. Mr. Ziegler, have you reviewed that report?
Yes, Your Honor.
Do you agree that that would provide a factual basis for the charge in that file?
I do.
Mr. Seeger.
Likewise, Your Honor.
The court will mark and admit that report as court exhibit 1 and file number 255011. File number 255012, also a UDAA charge. The court will refer to Kalkaska County Sheriff's Department report number 244004482. Mr. Ziegler, have you reviewed that report?
I have, Your Honor.
Do you agree that the information in that report would provide a factual basis for the UDAA charge in that file?
Yes, Your Honor.
Mr. Seeger.
Likewise, Your Honor.
The court will mark and admit that report as court exhibit 1 and file number 255012 as a factual basis for that charge. Finally, file number 255015, the court's referring to Kalkaska County Sheriff's report number 244004437. As to the charge of home invasion and UDAA, Mr. Ziegler, have you reviewed that report?
I have, Your Honor.
Do you agree that that information in that report will form a factual basis for those two charges?
Your Honor, I think as to the UDAA in that file, I provided the court 2 reports. So there's a second number, and the reason for that was that at the time, it was unclear who had taken the vehicle, but a later report, a deputy had seen Mr. Barkovich driving that same vehicle.
Okay, so the UDAA would be as to Kalkaska report number 244004451.
Correct.
Okay.
I agree that both of those reports provide a factual basis for both of the charges in that file, Your Honor.
All right, thank you, Mr. Seeger.
Likewise, John.
Okay, so the court will mark and admit both those together as one exhibit, court exhibit 1 in the file number 255015 as the factual basis for finding that. Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Seeger?
No, sir.
And Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule and taken it as no contest plea?
Yes, Your Honor.
Mr. Seeger?
Yes, sir.
Mr. Barkovich, the court finds that your plea is knowing and voluntary. The court is satisfied based on the information contained within the police reports that I've marked and admitted in each of the respective files that there is a factual basis to support a finding that you are guilty of each of the charges that you've pled no contest to in this case. The court will accept your no contest plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. We'll have you transported here to Kalkaska County to be in court in person for the purposes of that sentencing hearing. Between now and then, somebody from the probation department will be in touch with you to prepare a pre-sentence report, and then you'll have an opportunity prior to sentencing to go through that report and talk to your attorney, Mr. Seeger, about that. Ziegler, anything further we need to address on these files today?
No, Your Honor.
Mr. Seeger.
No, sir.
Mr. Barkovich, did you have any questions at all?
No, sir.
Okay, thank you. That's all for this hearing today, and the court is going to disconnect at this time.
Yep, thank you.
Your Honor, I do have Mr. Goodrich in the courtroom and Mr. Patrick. Mr. Goodrich should be very brief.
Okay, People versus Jeffrey Goodrich, file number 255023. Record should reflect Mr. Goodrich is present here in the courtroom today. How did we want to proceed on this file, Mr. Seeger?
Your Honor, at this time, I would ask the court to consider giving this one final jury status conference in the attempt to resolve the file. In the event that we're not able to resolve it, Your Honor, then I guess we will proceed to trial. The case does appear to be triable. It's the report, but be that as it may, Your Honor, he also has some additional files that he's attempting to resolve in Antrim County that are somewhat of a subset of this particular case. So in any event, Your Honor, if you gave us one additional status conference, either we're able to resolve it or we're not.
All right, do you have any objection to that, Mr. Ziegler?
No, Your Honor.
Okay, so we'll set this for a plea cutoff hearing in 30 days. So between now and then, Mr. Goodrich, I just need you to make sure you talk to Mr. Seeger about any offers that are out there. And that when we're back next time, that you're ready with a final decision as to whether you want to accept that or proceed to trial. Okay. All right. Thank you. That's all for today.
And then I have Mr. Patrick, Your Honor, for sentencing.
Okay, Mr. Patrick, if you'll come forward. It's on the record as People versus Darnell Patrick, file number 244981. The record should reflect Mr. Patrick's present here in the courtroom today. This is the date and time set for sentencing in this matter. And Mr. Patrick, have you had an opportunity to go through the pre-sentence report and talk to Mr. Seeger about that?
Yes.
Mr. Seeger, are there any additions, deletions, or corrections that need to be made to that report?
No, Your Honor.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
And anything on behalf of the people for allocation today?
Your Honor, I largely support the recommendations contained in the PSI. My only issue or request would be that Mr. Patrick has 3 days jail credit. The OWI second statute says that there must be at least 5 days jail. So I think whether the court is considering placing Mr. Patrick on probation, I believe the court statutorily needs to order an additional 2 days jail to be served at some point. I think he's already served the 3, he's already served at least 48 hours consecutive, so that's not an issue, but 2 more need to be served. So whether the court is considering jail, that's one thing that would resolve that issue. But if the court is going to follow the recommendation, I would just ask the court to order 2 days to be served at some point, whether it's today or in the future. Thank you.
Thank you, Mr. Seeger.
Yeah, likewise, I would just ask the court to generally follow the recommendation. I've spoke to Mr. Patrick quite a few times about this file, and he's expressed his remorse for driving while under the influence, recognizing that it's not only a danger to himself, but it's also a danger to the public. He recognizes that. He has done relatively well on bond. He's generally stayed out of trouble. His gainful employment. I'm hoping that this is a learning lesson for him, or well understanding that should ever this happen again, it can only end very badly. So be that as it may, Your Honor, I'm just asking the court to follow the recommendation. In terms of the jail, Your Honor, I do understand that statutorily it needs to be imposed, but whether or not it actually needs to be served is an entirely different question. The court doesn't always, I'm not sure how this court does it per se. In many other courts, it'll be held in abeyance. That's like by analogy what they would do with sobriety court, albeit this is clearly not sobriety court. Obviously, that would be a plea to a third, but because he's done well on bond, because he's not picked up any other charges, I would just ask the court to hold any additional jail time in abeyance to the extent that the court believes that he needs some kind of jail time. I would just ask that he be able to serve that on a weekend when he's able to arrange that with other obligations that he has.
All right, thank you. Mr. Patrick, anything that you wanted to say?
Yes, this was a dumb decision that I would never make again. I have a family and kids depend on me, and I want to set a better example for them. This is a position I never want to be put in, but this is not who I am. And I'm just thankful that nobody got hurt as well as myself. So.
All right. I did read through the report. I'm familiar with what happened in this circumstance. Your blood alcohol levels, of course, concerning. It was extremely high. You passed out or fell asleep during the course of the traffic stop, which tells me, the tests were probably accurate and that you were intoxicated to the level that, you were starting to fall asleep or lose consciousness. And the fact that you're behind the wheel is a frightening thing to me. Have somebody out there driving around in that condition. And I think you're absolutely lucky that you didn't kill yourself, or more importantly, some other innocent person that had nothing to do with your decisions to drink and drive on that night. I do generally support the recommendation, although I do think a longer term of probation is appropriate. I'm also going to follow the recommendation to the extent that, the statute requires you to serve 5 days. You're going to be required to serve those 5 days, either during the course of your probation at the end of it. So you got 2 more days to serve. I'm going to hold a fairly large amount of jail time in abeyance here. And I'm doing that hopefully as a motivator to get you to comply with probation, because again, my concern here is public safety. And to the extent that you're not complying with your probation, or in particular, if you test positive for alcohol or have any other kind of alcohol related offenses while you're on probation, I want there to be a really stiff consequence that, number one, it'll punish you for engaging in that conduct. Number two, hopefully it'll motivate you to stay sober and follow your probation. So I'm going to place you on probation for a period of 1 year. The court is going to adopt as the conditions of that probation all the terms and conditions listed in the report. I'm going to impose 6 months of jail. I'm going to hold that in abeyance. So if you violate your probation in any way, I can impose any or all of that 6 months, like immediately. I don't have to wait for a probation violation hearing. Do not pass go, it's straight to jail. Because at that point, what you're going to be telling me is that, drinking or not complying with your probation is more important to you than staying out of jail. To the extent that you do comply with your probation fully, and you don't serve that extra 2 days as part of a sentence, then you would be required at the end of your probation to serve 2 days in the Kalkaska County Jail. Again, you do have credit for 3 days served. Along with all the terms and conditions of the probation, a crime victim's assessment of $75, court costs of $325, attorney fees of $350, $53 state cost, and a supervision fee of $30, which can be of $30 per month while you're on probation. This is a misdemeanor offense, so there are no written appellate rights. You do have the right to appeal this sentence, though. If you wanted to do that, you would need to file for that appeal within the next 21 days. If you have more questions about that, then Mr. Siegel would be able to answer those questions for you. Agent Barrett, did you want to meet with him before we leave? So just make sure you touch base with Agent Barrett here before you leave court today. Mr. Ziegler, anything else that we need to address for the record here today?
No, Your Honor.
Mr. Siegel?
No, sir.
Good luck to you going forward, Mr. Patrick.
Thank you.
Your Honor, I just want to make sure there's no arraignments or anything. Actually, I think that may have been Judge Hunter that asked me to show up on Wednesday.
I have not been made aware of any.
Okay, that's fine.
All right, let's take a short recess and we'll come back on the record and talk.
Indicated he would oppose those.
The older ones, are they character letters? What's the nature of
The nature is character, yes.
Mr. Ziegler?
Your Honor, many of those letters are either undated or expressly dated from 2018. So they relate to the prior offense of Mr. Trepanier. At least 4 or 5 of those letters indicate feelings to the effect of that he's a good person and it's out of character for him and he would do this sort of thing. I think those letters are largely irrelevant primarily because they don't have the benefit of knowing what has happened in this case at this trial and this conviction. So I think those letters are not properly considered today by the school.
All right, I'll review them. Just as they relate to Mr. Trepanier's character generally, although I obviously recognize that they were written prior to trial at issue in this case. So number these. So I'm going to go off the record real quick.
Thank you.
Have had on my life. I was only 15 years old when I became a victim of this heinous crime. I am now 31, and the scars of that traumatic experience still echo through my daily existence. The violation of my childhood innocence has left me grappling with the aftermath of that day and the years that followed. His behavior was not just a one-time incident. It has triggered a myriad of psychological struggles that continue to haunt me. I live with the constant burden of post-traumatic stress disorder, which has manifested in various ways, including frequent nightmares that transport me back to that traumatic day, waking me in terror and drenched in sweat, severe insomnia, where I often lie awake for hours, my mind racing with worry and fear, dreading sleep, flashbacks that invade my thoughts unexpectedly, making me feel as if I am reliving the trauma all over again. Heightened
We're gonna take a short recess. Hold on a second.
Sister, the consequences of his actions must reflect the severity of the crime, not only for justice, but also as a deterrent to ensure that no other child has to endure what I went through. I urge you to impose a sentence that acknowledges the lasting damage inflicted upon me and serves to protect others from experiencing similar pain. Thank you for allowing me to share my story today. The victim's statement, Your Honor.
All right, thank you. Anything that you wanted to state for?
Yes, Your Honor. Your Honor, the court's well aware of the background of this case, having presided over the jury trial. I don't want to belabor the facts, but I think it's incumbent on me to reiterate that this is the defendant's second conviction for essentially the exact same kind of behavior. I think the victim used the term predatory conduct. That's exactly the term that I was going to use. He was targeting young girls in the exact same house, taking advantage of their age, their relationship, their location in the same house, and perpetrating crimes against them. This is the second time the defendant has been found guilty by a jury of his peers for criminal sexual conduct. The penalty for his second offense should reflect both the heinous nature of this particular offense, as well as the fact that he has subsequently reoffended. In terms of the scoring, Your Honor, the guidelines are 45 to 75 months. The scoring in this case is rather unusual because this offense was committed in 2009, before most of his criminal history and before his other CSC. That means most of his, what I'm going to call prior record, prior to today's date record, does not score. And the subsequent CSC only scores for 10 points as a subsequent felony conviction, rather than 25 points for a high severity felony conviction. It also cannot be used to enhance his conviction, whereas I had initially charged it as a habitual second offense notice. That's not permitted due to the timing of the offenses. All of that is to say, Your Honor, that the scoring could have gone much worse for the defendant, because we are required to disregard, for scoring purposes at least, the criminal record he has attained since this offense. The court, however, should not disregard it entirely, however, but consider how he has conducted himself since this offense when determining what the appropriate punishment is for this offense. Another thing to take into account is the defendant's lack of taking responsibility for either offense. He continues to deny sexually assaulting Olivia Date. Even to this day, he testified to that during the trial. He continues to deny any wrongdoing, both under oath at trial and to the PSI author in this case, despite clearly admitting wrongdoing to Detective Helene in that interview. The defendant tells the PSI author that everyone lied at his trial, when very clearly either he must have lied to Detective Helene or he must have lied under oath. The defendant's refusal to accept any responsibility for his actions when his guilt is plainly obvious demonstrates a lack of remorse on his part and suggests he would continue to be a danger to the community in general and to his prior victims in particular. The defense will likely argue this offense occurred a long time ago and that therefore his offense does not warrant a sentence at the higher end of the guidelines. I disagree. Had the offense been committed a long time ago and he had not engaged in other predatory sexual acts, that might be one thing. Had this happened a long time ago and the defendant expressed remorse and a desire to change, that might be one thing. Had this happened a long time ago and the defendant didn't try to pin blame on the victims or on the system or on the officers or on everyone and anyone but himself, that might be convincing. But the defendant has done none of those things. He's done nothing either since his prior CSC or since he was charged in this case to suggest he does not continue to be a danger to young women or that he stands any reasonable likelihood of rehabilitation. The defendant is a predator, plain and simple. He has demonstrated a pattern of engaging in sexual activities with minors. Whether one offense happened before the other or vice versa is not the operative question this court should consider. The fact that there are multiple and the fact that the defendant has not changed his ways in between is the issue that this court should consider. Given the nature of the crime, given the defendant's history, his lack of remorse, the very clear nature of his guilt, a sentence at the top end of the guidelines is very clearly warranted. Further, given that the guidelines, because of the unusual timing of these cases, do not take into account much of the defendant's record, particularly his other CSC, an upward departure would be appropriate and proportionate in this case, Your Honor. Even if the scoring simply allowed 25 points for the 2018 CSC conviction under PRV 1, the scoring would change from 45 to 75 to 72 to 120. So my ask would be this, Your Honor. If the court is unwilling to depart from the guidelines, a sentence of 75 months is more than justified. And I would ask the court to sentence the defendant at the top end of that guidelines range. However, I would ask the court to consider fashioning a sentence above the guidelines that more appropriately and proportionately addresses the defendant's conduct, his history, and his lack of remorse. Primarily because while the guidelines changed significantly based on the order of his convictions, his danger to the public and to the victims. Thank you.
Mr. Travis, anything on behalf of this one?
Thank you, Your Honor. Your Honor, the prosecutor is right. I would ask the court to point out in the PSI is scored and crafted the way it is because of when this event occurred. He does actually get punished for his subsequent felony conviction. It may not be as high as that this occurred after the fact, but that's a factual impossibility. This occurred prior. And the way the guidelines are set up, he is still being punished in these guidelines for having another conviction. So I think the guidelines appropriately account for the situation. I understand Mr. Trepanier has been clear that he doesn't agree with things. Your Honor, was part of the trial you heard. It's not even that he denies that an incident occurred. It's just that this is an incident that happened 15 years ago, and the parties have a different recollection as to what occurred. He is standing by his recollection. I think that he shouldn't be punished for standing by his belief and his memory. I wasn't there. I don't know. The jury made their decision based on the testimony, and this is what we argued. I would ask the court to grant a sentence within the guidelines and towards the lower end, taking into account that this did occur 15 years ago. Thank you.
Mr. Trepanier, anything you wanted to say?
First of all, I want to apologize for the last time I was here. None of that was directed at any of you guys. Directed at that man right there for many reasons. The video of me, my confession is a false confession because just before that, which nobody seems to be able to find the video before that, because that's not where this starts. I got there at 9:30 in the morning and I didn't leave until after the video that was played here in this courtroom. And after I pulled all the stuff off, he come in the room, told me I was a liar. And then I said to him, which I've been trying to get the video since the video came out. I said, not unless she was 15 in 2000, after June of 2010. And he said, is that when it occurred? I said, yeah. And he said, she was. And that's how you got to where the video, anything in that video was played. That's why I said that. And I don't deny ever saying none of that. But her and I slept together twice in 2010 after my annual training in June of 2010. And it was, she propositioned me, and I can't get the phone records, or I would have. We tried, and they said they didn't have them. It was, I was living in here in Calcasieu, and that like they didn't do any investigation. They didn't ask my girlfriend, my fiance at the time, and who I was with in December at a house. We had two cars. We were paying on one from North Point Motors with both our names on it. We lived at 311 South Orange Street. We had two dogs and a cat. Where were they at? Like, she said I was homeless and stuff. None of this came, like, I never got to say any of this. None of this. This didn't even happen. This past 5 years are going down the drain for me. I've changed so much as I have just trying to stay, like do what I have to. I got my family, we got a house, she's about to lose that. We already lost our car. Nobody listens to anything I say. Where's this video at? I was told that they believe that I believe that that's what I said. And that's happened. But where's this video? It's an MSP post. Don't they record that? Where's the rest of the video? Why is it only just that? Even if it was a poly from start to the end of that video, where's that at? I understand the poly can't be played here, but why was that video then? That's part of the video. I'm sitting in the poly chair. Not to mention anything that has to do with any of it. I wasn't there. I have a person that could have been here who wasn't, because she didn't get brought in because the private investigator that talked to her, she thinks she's a character witness. We don't get along. She's not a very good character witness, not to mention she thought she was cheating on her the whole time because she was cheating on me. But that's neither here nor there. But I know for a fact, she can tell you I was in that house because I asked her to marry me December 4th of 2009. I was not at that house. I had my own house. I had my own stuff, my own life. I have it now. The past 5 years since 2020, when I got out, I've been trying to build my life back. I've been doing everything I can. All it's doing is setting me back. For what? Because she's mad because it was the previous charge that I already paid for? That's all this is. And I haven't had an Instagram in I don't know how many years. And that's exactly what she's talking about. There was no investigation at all. Nobody but the PI asked my ex-girlfriend anything. They didn't ask Chuck anything. Her stepdad, my stepdad didn't. Nobody did anything. Except for ask me and her. He has the only written statement I ever made, and that was to Helene the first time I went there because he sent me away and rescheduled because he thought I was nervous. He didn't want to do the test that day. And then he wasn't even there. Both times. I called him the first time, I asked him why he wasn't there. He should have been, no matter what. Especially in that situation. None of this happened. I can't show remorse for something that never happened. And I apologize that you guys like look at it the way you do, but how can nothing that didn't happen? Especially when she was in 2009. She was 16. Last I checked, 16 was the legal age for her consent or her mother, whatever, how that worked back then. And I was 25. And then he tells me that my baby mama wasn't relevant either, but she knows the whole story. She was there. It's the same, around the same time we got together. Yeah, she was 17 when we got together. And I made her wait till she was 17. And she had our daughter at 18. We were together for a while, long time. And after that, I stayed away from people. I didn't meet Lisa until 2.5 years ago. And I didn't want to do that. I was afraid to be with anybody. Lost my daughter because of this.
Mr. Trevor, is there anything else that you wanted to say? All right. So obviously I'm familiar with the facts of this case. I presided over the trial. I heard all the testimony. I reviewed the pre-sentence report. I'm familiar with all the information in that report. I did review the letters that you submitted. I take all that into account along with what the lawyers had to say here today and yourself, Mr. Trepanier. The first thing I would say is I don't second guess verdicts of the jury. As you heard when I instructed the jury, what they decide about any fact in the case is final. So it's not my job to retry the case as part of sentencing. I accept the verdict of the jury. I think it was supported by the evidence. And there are 12 people who didn't know anything about this who came and listened to all the evidence, including your testimony, and they made their decision. So my sentencing is based on the decision that they made. And that is that you had sex with a girl who was underage. I think there's been some improper suggestions that because this young girl may have consented, that somehow that relieves you of some level of responsibility for having sex with her. But that's not how the law works. So she's 15 years old, she can't consent. And as an adult, you have the responsibility of exercising better judgment. Even if an underage person wants to have sex with you as an adult, it's your responsibility to say, you're too young to know what you want and what you don't want. I'm an adult. I'm going to exercise some self-control here, and I'm not going to have sex with you. And that's what you should have done, and that's where you've gone wrong in multiple occasions. And what that tells me is that you're not able to control those urges. Even as an adult, you're not able to exercise the kind of responsibility that you have to look out for people who are younger than you, who don't know better. And in my view, you took advantage of the young lady in this case, and this wasn't the first time. Which helped controlling that, and that if you're presented with that situation again, there's a basis that you're going to be shown multiple times that that's how you operate. So I do not believe, given the circumstances here, given the age of the case, given the underlying circumstances, that departure is warranted. I think if the court were to do that, I would be relying on facts that I specifically am not allowed to rely on in terms of sentencing because of the guidelines. So I don't think the court would have adequate justification for departing. However, I do believe, number one, I can take into account other convictions, whether or not they happened before or after, as a way of viewing this as a course of conduct. And so for that reason, I do believe that a sentence at the top end of the guidelines is necessary. Number one, because I do think you present a danger to underage girls, that you would reoffend if you were given the opportunity to do that. That you're not particularly interested in making sure that girls are of age before you have sex with them, which again gives me concerns for public safety going forward, and that other young ladies could be victimized. So for those reasons, I find that a sentence at the top end of the guidelines is appropriate in this case. The court is going to sentence you to Michigan Department of Corrections for a period of 75 months to 15 years. You do have credit for 48 days served. The court is going to order a crime victim's assessment of $130, court costs of $325, attorney fees of $350, and $68 state costs. You do have the ability to seek an appeal of the sentence. And Terry, all right, Mr. Trepanier, these pages are going to explain to you what your appellate rights are. So, attorney to help you with an appeal. Yes. You are remanded to the custody of the state at this time.
Am I allowed to say goodbye to Mom?
Nope, you need to go with the officers. Cool.
Listen. You're not letting me. Say goodbye to you guys.
backtrack a little bit to our 9:45 hearing. People versus Timothy Hiddle, 2004-4993.
Here now, swapping out for Bonnie.
Mr. Hiddle present today. Courtroom. This is set for both of these files. I believe Mr. Hiddle failed to appear for you. We have an excellent.
I believe Mr. Hiddle did not get the notice and at the time, we don't have very good communication. He did thankfully appear yesterday for a court date in district court. I believe he was handed that notice. I do know, and I think that, thank Your Honor for setting it for a show cause. I've had difficulty even mailing things to Mr. Hiddle. I've gotten the vast majority of things returned. So I think he just struggles to get mail.
Great. Mr. Hiddle, is there a reason why you're not staying in contact with your attorney?
My phone, I only have Wi-Fi, a Wi-Fi phone, basically, so only when I'm around Wi-Fi, I can be able to call or text or anything like that. And just between that and being able to, I don't have Wi-Fi, so I go down to a neighbor's house, and it's just been hard to get a hold of them throughout the, I didn't realize I even had a court date. I didn't even hear that, I had another court date.
All right, do you have a mailing address?
I do, that is gonna be a change. Can I use your address for mailing address?
Yeah.
Okay, we have a Main Street address.
Yeah, it's gonna be a Main Street address, so just, this one, I know that I ain't gonna have my paperwork that mess with, and I think somebody was actually taking my mail out of my mailbox, but I'm not 100%, so.
Okay, what's a good address for you right now?
5665 West Main Street, Rapid City.
That was 5665. All right.
I'm gonna for sure get my mail there for sure.
Okay, so we're gonna send your mail there, including your notice of court hearing. I'm not gonna impose any penalties today for your failure to appear, but I just want to warn you that, your obligation, one, to stay in touch with your attorney, two, to notify the court if you have address changes. What happens is if you continue to fail to appear, at some point, not having Wi-Fi or not having the right address is no longer good. And the only way then for us to make sure you appear is to revoke your bond and hold you in jail. So if you want to remain out on bond and stay out of jail, it's in your own best interest to stay in touch and to show up for your hearings, okay? Going forward, Mr. Travis, how did we want to address these files today?
Your Honor, we would ask to set both files for trial. As I said, we've been able to talk because the case has been going on a number of times about the file, but Mr. Hiddle did bring up some new issues. One of the reasons we had to adjourn last time was so he could go through the body cam. So I guess I say all that because I would ask for a jury status ahead of that and a cutoff, because there are still some things that I would like to discuss with Mr. Hiddle and with Mr. Ziegler. But at this point, I think we are headed towards trials.
All right, so Mr. Like the 244993 was charged first, is that correct?
That's correct.
Setting that one for trial first.
Yeah.
Mr. Travis, do you have any objection to that?
Yeah, just I don't have it in front of me. What charge? Okay, no, I think that would probably, it is a more serious file. If it's the first in time, that would make sense.
Okay, so we'll get that one docketed for trial. That's again 4993. Ziegler, how many days?
It's 1 day trial.
Mr. Travis.
Your Honor, yes, I think 1 day would probably be appropriate. There's, I think, 2 officers in my client. I think that's largely it for witnesses.
So we'll set it for a 1 day jury trial about 90 days out. Yes. Mr. Travis.
Yes, I believe so, Your Honor.
So we'll set it for 90 days out. We'll set this for final status conference on the day immediately prior to the trial date. That would be complete cutoff for that file. Did you anticipate any motion practice, Mr. Ziegler?
No, you're
Not at the moment, but I do want to discuss with Mr. Hill the issues he's raised, so I would ask him not to do that.
Okay, so the motions can be filed at any time, but they must be filed and heard no later than the date of that final status conference, and will also be cut off. The court will send out notice of the trial dates as well as the final status conference, again, one-day jury trial at about 90 days out. And then once that trial is concluded, then proceed with the other file. I will set the other file for conference on the same day as the final one. Mr. Ziegler, anything further that we can address on these two cases today?
No.
Mr. Travis.
No.
Thank you, Mr. Phillips.
Versus.
Douglas Way.
This is Miss Gillen.
Okay, Ms. Gillen will be with you in just 1 second, okay?
Okay.
Yeah, for the record, this is People versus Way, file number 255002. The record should reflect Mr. Way is present here in the courtroom. Mr. Travis, how do we want to proceed on this file today?
Your Honor, it is my understanding that Mr. Way would be accepting a plea offer this morning. My understanding of that offer is basically, I think you could pick either count 1 through 3, but that include a count of child sexually abusive material, aggravated possession, and the other 7 counts would be dismissed.
Okay, so plea to count 1, dismissal of all remaining counts.
That's correct. I don't think factually there's no allegations in any of those counts, so it doesn't make a difference.
Yes.
Okay. Mr. Way, have you had an adequate opportunity to speak with Mr. Travis about this plea agreement?
Yes, we discussed it yesterday.
Okay. Do you need more time to do that before we go forward?
No.
Okay. And what we've said here today, which is that you would plead guilty to count 1 in exchange for dismissal of all the remaining counts. Is that the same agreement that you've discussed with him?
Yes.
Is that how you want to proceed today?
Then yes, it's fine.
Okay. Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the true self you got?
I do.
Thank you. You can lower your hand. Mr. Way, are you currently on any kind of probation or parole?
I check in with a bail bondsman. I take P test, but I'm not sure.
Okay. That's
I'm out on bond. Is that
that's the bond in this case?
Yes.
Okay, but you don't have probation in this county or somewhere else?
I've never been in trouble for anything.
Okay. And you understand that by pleading guilty to count 1, that the maximum possible penalty you could face would be up to 10 years and or $50,000 fine?
I do.
With that in mind, what is your plea to that charge today?
Would be guilty.
So right now you have certain rights. And I'm going to go through those rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights?
Yes, sir.
And you understand that by pleading guilty, you're going to be giving up and waiving all of those rights, including the right to have a trial, and you won't have those rights anymore.
Sadly, I do.
Okay. Also, you don't have an automatic right to appeal the plea that you're making here today. Your only way to appeal it would be by leave. And what that means is that you would have to ask the next higher court up, you have to ask them to hear your case. They could say no, and then that would be the end of any appeal. You understand that?
Yes, and thank you for explaining. I was gonna ask that then.
Okay. Do you have any other questions about that? Okay. Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we said here in court today?
No, sir.
Is it your own free choice to enter this plea?
Yes.
Are you pleading guilty because you are actually guilty of this crime?
No, but it's the safest route, I guess, because the facts are stacked against me, I guess, so we're just opinion. I don't know. It's safer to take it this way, I guess, instead of only 6 or so, and the max amount for this stuff I could be an old man when I get out, so.
So one other thing I guess I want to explain to you, I cannot find somebody guilty because it is their best option. I can only find someone guilty if they are actually guilty, which is why I asked that question. So, in other words, I can't find an innocent person guilty because they're going to get a better deal than if they went to trial. I can only find guilty people guilty.
I guess I should say that I just don't believe I'm guilty because of all the circumstances leading up to these, but in other people's eyes, it could be seen other ways, so.
Well, how about, I'm going to ask you some questions and then we'll see what your answers are. And so the allegation is that this was happening on or around June 24th of 2024. Is that the correct time frame?
I believe so, sir.
Okay. And did these things happen here in Kalkaska County? Were you located within Kalkaska?
No, I was in Clearwater Township down in Rapid City. I'm not sure if that's part of Kalkaska County though.
Okay. I think Mr. Ziegler and Mr. Travis can acknowledge that that is part of Kalkaska.
Rapid City is part of Kalkaska.
Yes, sir. Okay, then yes, it is.
All right. And so did you have some videos depicting some people engaging in sexual acts?
I did, but that was retrieved from a porn site because I had an addiction and sorry.
So you had some videos with that kind of material. Is that correct?
Yes.
Okay. And you downloaded that, you looked at it.
I did not purposely download them. I clicked play on a video and it popped up under the screen and they were downloaded to my phone. I deleted them, but I got kind of flagged. They were still in my deleted files, and so they were still on my phone.
Okay. So you did click on it,
not
to look at it.
The porn video was not depicted as a child. It was just a regular woman man kind of video. You hit play, and it would pop up some add-on and just download it to my phone.
Okay.
I tried to get it off as quick as possible, but it.
So I'm going to ask for some help with counsel, given the lack of real detailed information in file. So either Mr. Travis or Mr. Ziegler, you asked some more specific questions. I'm not sure how the information was obtained, what it actually showed.
That was the one that popped up in the video. Like he asked to see it, and it was in my files. I thought he was there to help me, but he was not. I was just being truthful with him that yes, they had gotten on my phone where I had deleted them, and then I had to go into those deleted files to put it on my phone to show them.
Your Honor, maybe we should pass this for a minute. I should speak with Mr. Way a little more.
Okay. So Mr. Way, you can just have a seat. I'm going to give you an opportunity to have some further discussions with your attorney, okay?
Where would you like me to sit?
Just start here in the galleries. Okay, Ms. Killen, are you able to hear me okay?
I am. Are you able to hear me?
Yeah, thank you. Okay, so we'll go on the record in People versus Megan Killen, file number 255017 and 255042. The record should reflect that Ms. Killen is present today by video from the Wexford County Jail. And these files are set for status conference today. Mr. Trevis, can you tell me where things are at with these two files?
Yes, Your Honor, it's my understanding that we have a plea offer on both files to resolve them. My understanding of that offer would be in 255017. Ms. Killen would plead to a for your possession of narcotics without any enhancements. And then in the newer file, 255042, she would plead guilty to the OUID with minor present charge, and the other narcotics charge would be dismissed.
That's correct. Okay, so the file number 5042, that would be the misdemeanor, 1-year misdemeanor.
Correct.
Yes, yes.
All right, Ms. Killen, were you able to hear that?
I was, but the CO kind of came in and the door slammed. It was, can you repeat it for me, please?
Sure. In file number 255017, in that file, you're charged with possession of methamphetamine, which is a 10-year felony. The plea agreement would be to plead to possession of a narcotic, which is a 4-year felony, in exchange for having the more serious charge dismissed. And then in the other file, you would plead guilty to operating while intoxicated or under the influence of drugs with an occupant in the car under 16, and that is a misdemeanor. That is 1-year misdemeanor, and the other charge in that file would be dismissed.
Okay, yeah, yep,
Is that the plea agreement that you've discussed previously with your attorney?
it is.
And did you want to go forward with that agreement here today?
I do.
Okay, can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can lower your hand. Ms. Killen, are you currently on any kind of probation or parole?
I'm not.
All right, and as I indicated, you're going to plead guilty to 1 count of possession of a narcotic that carries with it a maximum possible penalty of up to 4 years. Do you understand that?
I do.
And then the driving under the influence with a person less than 16, that's a 1-year misdemeanor. Do you understand that?
Yes.
With those maximum possible penalties in mind, what is your plea to each of those charges today?
Yes.
How did you want to plead to those charges?
Oh, sorry, guilty.
Okay. Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. You understand that you have all those rights.
I do.
And you understand that you're going to be giving up and waiving all of those rights by pleading guilty.
I do, yep.
Also, you don't have an automatic right to appeal the plea that you're making here today. The only way you can appeal it is by leave, and that means that you have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. You understand that?
I do.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we've said here in court today?
No.
Is it your own free choice to enter this plea?
It is.
Are you pleading guilty because you are actually guilty of each of these charges?
I am.
So as to the possession of narcotics charge, the information I have indicates that that happened back on May 28th of 2024. Is that correct?
Yeah.
Back at that time, were you present here in Kalkaska County?
I was.
And while you were present here in Kalkaska County, did you have possession of some methamphetamine?
I did.
Did you know that that's what that substance was?
I did.
Did you have any legal right to have possession of any amount of it at that time?
None.
All right, and then the second incident when you were driving, I have that occurred more recently in March 20th of 2025, is that correct?
It is.
Okay. On that date, had you been consuming a controlled substance?
Yes.
And after you consumed that controlled substance, did you operate a motor vehicle in or around the Taco Bell here in Kalkaska?
I did.
Okay. And because of consuming that substance, was your ability to operate that vehicle in a normal and safe way affected? Were you unable to operate that vehicle normally and safely?
Yeah, it was affected.
Okay. Did you have a person with you who was under the age of 16 at the time?
I did.
All right. Mr. Ziegler, are the people satisfied with the factual basis?
Yes, sir.
Mr. Travis?
Yes, Your Honor, I guess I would just note, and you wouldn't disagree that there was fentanyl and methamphetamine found in your blood?
No.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record? Mr. Travis?
No, Your Honor.
Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Yes, Your Honor.
All right. Ms. Killen, the court finds that your plea as to both charges is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of each of these charges. The court will accept your guilty plea as to both. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Someone from the probation department will be in touch with you to do a pre-sentence report. And then you'll have an opportunity to meet with your attorney and go through that report prior to sentencing, okay?
Okay, thank you. Do you want me to end this Zoom or leave it on?
1 second, that's a good question.
Your Honor, I have Buck Hiddle, who I think is there, but I'm not 100% sure.
I have him as too. Miss Killen, can you ask the corrections officer to bring Buck Hiddle into that room?
Yep, I can.
All right, thank you.
Yep, have a good day.
While we're waiting for that, Mr. Murphy here. Mr. Murphy, were you ready to proceed with this sentencing?
I am.
All right, he's on his way.
Thank you. Right up here with the court officer to be able to. We're on the record in People versus Pamela Bunning, file number 255029. The record should reflect today. This is the date and time set for sentencing in this matter. Ms. Bunning, you had a chance to go through the pre-sentence report.
Yes.
Mr. Murphy.
Yes.
Mr. Murphy, are there any additions, deletions, or corrections to the report?
Judge, I reviewed the report with my client. Based on our review, there is no additions, corrections, deletions. And we're also satisfied with the scoring guidelines in this matter.
Thank you. Mr. Ziegler, have the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Anything by way of allocution on behalf of the people?
Your Honor, I support the recommendations contained in the PSI. I think they're appropriate. It's a possession of narcotics case. Ms. Bunning has already served 110 days. I think that's a sufficient penalty at this time in terms of incarceration. I would support placing her on probation for a term of 12 months. Give her an opportunity to demonstrate that she can comport her behavior with the law. And then obviously if she cannot, there would be additional penalties. But I think that the time she served is appropriate for the crime. So I would ask the court generally to adopt the recommendations.
Thank you, Mr. Gertie. Anything on behalf of Ms. Bunning?
Just briefly, Judge, Ms. Bunning is 40 years of age, 1 prior misdemeanor, 2 prior felonies, a limited criminal experience. There was a manslaughter, there was a prior that she was convicted for, and it has done her time. But however, with this matter, Ms. Bunning was cooperative with the officer, helpful to the people, and that's why she received the benefit of this plea offer. I think the recommendation is appropriate and ask you to follow it, Judge. Ms. Bunning indicates that while on probation, she would continue with either outpatient or inpatient treatment based on what her probation officer recommends and will work out. So I think that's a good plan for Ms. Bunning to continue with sobriety going forward. So I'd ask you to follow the recommendation, Judge. Thank you.
Ma'am, anything you wanted to say here today?
No, I would, if I had the choice of rehab, I would like to do outpatient so I could continue to work and do my job. And I will be refining with my parents who are here today. I learned my lesson. Just I'm here to hopefully maintain my sobriety.
I did read through the report. I'm familiar with what happened in this case. I'm familiar with your background and circumstances also based on the information in that report. I take all of that into consideration along with what the lawyers and yourself had to say here today. You know, 2 things kind of stand out to me. Number one, your people you're associating with are, I see them, I recognize a lot of those names. I hope that you can make a break from associating with them because I'm sure you already know this, but the people that you hang around with are going to affect your quality of life in a lot of different ways. And these folks are only going to get you in more trouble, particularly when you're on probation. You can't hang around them anyway,
right.
But aside from that, if you can find a different group, I think it would benefit you. And then I also agree that, you know, seeking some treatment, some counseling, you've been through some things obviously in your life that I think would reasonably contribute to someone having issues with substance abuse. And the more that you can deal with those underlying things, the better you can be able to deal with substance.
I do down at the jail, healing private wounds. They have grief counseling and stuff down there that I want to also, you know, try to get into that too. Like they have great grieving counseling and, you know, substance abuse counseling, stuff like that. So.
Yeah, so I think you should try to take advantage of as many of those kind of things as you can, because I think that'll all be helpful to you. So I hope that's what you do during your time on probation. I do think the recommendation is appropriate, though. I agree with what the attorneys have said. 110 days is a sufficient sanction, and I think probation is appropriate again to monitor and hopefully provide you with some resources to get the kind of help that you need. So the court is going to adopt the recommendation to probation for a period of 12 months. The court is going to adopt as the conditions of the probation all the terms and conditions listed in the report. The court is going to sentence you to 110 days in the Kalkaska County Jail with credit for 110 days served. Crime victims assessment of $130. Court costs of $325, attorney fees of $350, DNA testing fee of $60, $68 state costs, and supervision fee while you're on probation of $30 per month. You do have the ability to seek an appeal of this sentence, and we're going to provide you with some papers that explain what your appellate rights are. Mr. Murphy has acknowledged receipt of those. Right?
Yes, Your Honor, for the record, Ms. Bunning does have a copy of her paperwork as well.
Ms. Wagner, are you gonna meet with, Ms. Bunning before she's released?
Can she, when she gets out today, can you just, direct, Pam, just come over to my office, please, after, you get released?
Okay.
Thank you.
Thank you, Judge.
All right, good luck to you going forward.
Thank you.
I can't even.
Back down in Monterey jail.
Mr. Hiddle, I'm just gonna need you to unmute on your end there, please. All right, we're on the record in Keepo versus Buck Eugene Hiddle, case number 234859. The record should reflect that Mr. Hiddle is present today by video from Wexford County Jail. And Mr. Travis, can you tell me the status of this file?
Yes, Your Honor, Mr. Hiddle's got this file and another file that I don't know actually what judge that's assigned to. I would imagine it's getting assigned to Your Honor. There is a full resolution plea offer. That plea offer would be to plead in this file to an R&O with no enhancements, and into the newer file dismissing count 1 and pleading to an R&O with no enhancements. There are some misdemeanor files that Mr. Hiddle would be agreeing to pay restitution on, along with the prosecution has agreed that if he takes this offer, he has a co-defendant in one of those misdemeanor files. It's a retail fraud that the co-defendant's case would be dismissed if Mr. Hiddle took this offer. Last I spoke to Mr. Hiddle, he did ask me to inquire with the prosecution about a better offer. That was declined by the prosecutor, and I haven't had a chance to tell Mr. Hiddle that because it was happening kind of quick with things. But as we stand, that is the offer, and unfortunately, there has been no change in that plea offer.
Okay, Mr. Hiddle, were you able to hear all of that?
Yes, I was.
Okay, how did you want to proceed today? Did you want to accept that offer, or did you want to have some time to discuss further with your attorney?
Can I have more time to talk to my attorney?
Okay. So, Mr. Travis, what I'll do is set this for a hearing on the court's next available date, but also set the other circuit court file at the same time so that we have both files together. If we have an agreement at that point, we can go forward. If not, then we'll set the cases for trial.
Thank you, Your Honor.
Mr. Hiddle, do you have any questions about how we're going to proceed with your case?
I think I'm pretty well on how it's going to proceed. Is there any way that I could get a bond reduction though?
Mr. Travis?
Your Honor, there's two files, and actually there would be, to effectively have a bond reduction, it would be the two files in front of Your Honor. And then there's also some misdemeanor files that are not in front of Your Honor. But I do believe the largest bonds are on the 2 felony files. Mr. Hiddle has been incarcerated for, I'd say a month and a half now, roughly. And is unable to post, somewhat partially due to the number of the files, but he is unable to post the dollar amount in this case and the new felony case.
In this case, I can't recall whether this hearing was in front of Your Honor or whether someone else was covering it, but the history of the file that's currently in front of Your Honor, Mr. Hiddle has failed to appear. I don't even know if I can count how many times, Your Honor. It's probably in the area of at least half a dozen. 3 bench warrants have been issued in addition to the original warrant. Your case dates back to 2020. I also have a misdemeanor case from around that time that dates back to 2019. One of the charges on the new file, which is not yet before Your Honor, it's file 255049. is a charge of absconding on bond because he has repeatedly and continuously failed to appear for his court hearings. So for those reasons, Your Honor, I would oppose any sort of bond reduction unless and until the time of sentencing.
Okay. All right, I'm just looking through the file. It does appear accurate regarding, based on what prosecutors indicated, there have been numerous, and this is just this file, which is the only one I have in front of me today, and the only one on the docket. But yeah, numerous bench warrants have been issued, the most recent of which was from November of 2024. So given the history of failure to appear, Mr. Biddle, the court finds that it would be inappropriate to lower the bond at this time. So the court's going to deny your request to modify the bond, and we'll proceed with hearing as I've indicated. So that's all for today. The court's going to disconnect from Wexford at this time.
Thank you.
Thank you. Sir, at Department of Corrections, can you tell me your name, please? Can you tell me your name, please, there at the Department of Corrections?
English.
Mr. English, okay. Mr. Horowitz, were you ready on Mr. English's matter? We'll call People versus Michael James English, two files, file number 244923 and 4925. The record should reflect Mr. English is present today by video from Michigan Department of Corrections. If I could have counsel put your appearances on.
Michael Horowitz on behalf of Mr. English.
Okay, this is set today for a motion hearing. Mr. English filed a motion to have these files dismissed based on a violation of the 180 day response. Mr. Horowitz, anything that you wanted to say by way of
Forever, such that they end up not getting credit on their new pending cases. Thank you.
Thank you, Mr. Zimmer.
Your Honor, I would largely rely on my written motion and the cases cited therein, just strictly for the notion that the 180-day rule does not require the trial to commence within 180 days. It only requires the prosecution to take some action to begin moving towards trial within 180 days. These cases were both charged before the defendant was even incarcerated in DOC. So there is no technical violation of the 180-day rule. I would rely on it.
All right, anything in response, Mr. Horowitz?
There you are. Thank you.
Okay, again, I did have a chance to review the written submissions by the parties. The oral arguments here today on the record are consistent with the arguments put forth in the written motions. I also had a chance to review the case law applying to the 180-day rule. First of all, the court would point to People versus Hendershot, 357, Mish 300, case going all the way back to 1959, interpreting the statute and the 180-day rule consistent with what prosecutors articulated, which is the rule does not require that the trial be commenced within 180 days, but that the prosecution make efforts on the case during that 180 period, and that the prosecution promptly prepares the case for trial. Any delays in the 180-day period will be charged against the party that's responsible for the delay. But again, case law is clear that as long as the prosecution makes good faith efforts to proceed promptly with pretrial proceedings, get the case ready, and eventually do trial, there can be no violation of the 180-day rule. In this case, the court notes a couple relevant facts. First of all, as the prosecutor indicated, these cases were charged before Mr. English's current incarceration, which involves conduct subsequent. Second, there have been some delays. However, Several of those delays were due to the Michigan Department of Corrections. The court would point to some of the more recent rulings, including People versus Witkowski, regarding the COVID pandemic, where the Supreme Court has ruled that those types of delays are not attributable to the prosecution. So the court finds that those delays could not be held against the prosecution. Court would also point to Mr. English's own conduct here in court, in which the court found him guilty of direct contempt for his behavior during one of the proceedings, in order that he be held in jail for 90 days on contempt. That is a delay that's clearly attributable to Mr. English and his own actions. So the delays that have occurred are not attributable to the prosecution and would not go towards the 180-day period. But even if they were, again, I agree with the prosecutor that I don't think it's applicable in this case, given the order of the charges and Mr. English's current incarceration, or order in time. And the court finds that the prosecution has proceeded diligently with attempting to bring this case to trial. And again, the trial is not required to occur within 180 days. So for all those reasons, the court is going to deny the motion. Mr. Horowitz, the court would request that you prepare an order that reflects the ruling of the court and submit that either under the 7-day rule or with the stipulation as to the form.
Your Honor, would it be acceptable for the motion to state the reason stated on the record?
Yes.
Now, I file a motion to have him removed from bench for being biased.
I'm sorry, could you repeat that? I couldn't hear you.
I want a motion filed to have him removed from my bench.
Okay, you're free to file that motion.
Judge. I want to file for biasness against me from you, because you are being biased. You're siding with the prosecutor on bullshit.
Okay, you're free to file.
And I will take this to the Supreme Court too.
You're free to file that motion at any time you would like to, Mr. English, and I'll rule on it accordingly. Okay, so for the record, Mr. English has voluntarily terminated his participation in this hearing by hanging up on his end. So I just want to make the record of that. Mr. Horowitz, anything else we need to address today?
No, Your Honor, thank you.
Mr. Ziegler.
There you go.
Thank you. Okay, Mr. Fragel, were you ready with your case?
Yes, Your Honor.
We'll go on the record in People versus Brian Crawford, file number 55036.
Patrick Fragel, we have Mr. Crawford.
Ryan Ziegler, yes.
Already. The record should reflect Mr. Crawford's present here in court today. Mr. Fragel, how did you want to proceed in this case?
The defendant intends to accept the offer to plead guilty to count 1, drunk driving, third offense, IBAC, with the understanding that if he completes 12 months of probation, the case would be reduced to drunk driving, second offense. There's no objection to prosecution at the 30-day mandatory.
About this agreement.
Yes, sir.
Solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Mr. Crawford, are you currently on any kind of probation or parole?
No, sir.
And you understand that if you were to unsuccessfully complete the delay in this case, that the maximum possible penalty you can face for the charge, which is operating the IBAC as a third offense, would be up to 5 years and or a $5,000 fine.
I do.
With that in mind, what is your plea charge?
I plead guilty to it.
So I'm going to go through your rights with you. I know you signed an advice of rights form. I'm sure you do that here on the record as well. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be found innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you want. You understand all of those rights.
I do.
And you understand that you're going to be giving up and waiving all of those rights by pleading guilty.
Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. The only way that you can appeal it is by leave, and that means that you would have to ask for the next higher court up to Court of Appeals to hear your case. If they said no, that would be the end of any appeal. You understand that?
I do.
Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what was said here on the record?
No, sir.
Is it your own free choice to enter this plea?
It is.
Are you pleading guilty because you are in fact guilty?
I am.
This incident happened back on October 2nd of 2024. Is that the correct date? On that date, were you drinking alcohol?
I was.
The alcohol, did you operate a vehicle on US 131 here in El Paso?
I did.
And at the time that you were operating that vehicle, was your ability to safely and normally operate that vehicle impaired because you had consumed alcohol?
It was.
Did you have any blood or breath tests to determine the level of alcohol in your system?
I did.
Do you remember what that result was?
I read it today. It was a 0.197 breath or blood and like a 0.10 breath.
Okay. Do you have any reason to doubt the accuracy of those tests?
I'm not gonna say I do.
Okay. Had you previously been convicted of operating while intoxicated back in 2001 in the 77th District Court?
I was.
And in 2006 in the 13th Circuit Court?
Yes, sir.
Mr. Ziegler, are the people satisfied with the factual basis?
Yes, sir.
Mr. Fragel?
Yes, Your Honor.
Mr. Ziegler, are the people satisfied, or I'm sorry, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Fragel?
No, Your Honor.
And Mr. Ziegler, are the people satisfied that the court has complied with statute? The court will take this plea.
Yes, sir.
Mr. Fragel?
Yes, Your Honor.
Mr. Crawford, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. It's important that you stay in touch with Mr. Fragel prior to that, and you're going to meet with Agent Vera here briefly today to set up a pre-sentence interview. Mr. Ziegler, anything else you need to address on this case today?
No, Your Honor.
Mr. Fragel?
Just a quick request on bond, Your Honor. The defendant has been submitting the daily preliminary breath test since October. I believe he started them voluntarily. I started them on my own. He's now taking some medication that causes him to sleep in a little bit. So we'd ask that daily PBT we move to the afternoon hours, so he doesn't miss any in the morning.
Any objection?
I don't have an objection to the extent that either the sheriff's department can accommodate it or he can make his own arrangements. I don't know where he's been testing or how they would accommodate that.
Okay. Yeah, I guess, Mr. Fragel, I would just, if you can submit a stipulation to the prosecutor, it sounds like he doesn't have an objection in principle, just that Mr. Crawford will obtain that PBT prior to 5 p.m. each day.
Okay. Thank you.
All right. Thank you. Mr. Germerty, were you ready on Mr. Galt?
I am.
Okay.
Thanks.
We're on the record in People versus Galt. This is file number 244943. The record should reflect Mr. Galt is present here in the courtroom today. This is set for a final status conference. We do have trial set to proceed beginning on May 20th. Mr. Ziegler, are the people ready to proceed as scheduled?
Yes, Your Honor. There's a few minor things Mr. Germer and I are working out. There's a couple of documents I still need to provide to him. I'm hoping to do that by the end of the week. But other than that, Your Honor, we'll be prepared to go on the 20th.
Mr. Germer, are you going to be ready to proceed?
Yes, we should be ready to proceed as well. My subpoenas are out. I know Mr. Ziegler and I are coordinating the order in which the witnesses are going to be called and the ones I'm going to rely on his subpoenas, so coordinating those nuances regarding the trial, so we should have no issues with trial.
All right. Mr. Ziegler, are you going to be utilizing any technology in the courtroom for exhibits to have the jury view exhibits?
I'll probably have some audio to play, Your Honor, potentially some body camera. And I'll probably, if I have time, prepare a slideshow for my closing. So yes, but I have the capability to do that on the screen here.
All right. I'll just ask that you test all of that out beforehand, so we don't waste any jury time. Technological issues, Mr. Murphy, are you going to be utilizing?
At this time, I'm going to rely on some exhibits that will be printed in print copy with the defense expert that's going to be called. I don't anticipate putting any of those slides on the television.
Okay.
That changes out something, tested out prior to, but at this point, I don't anticipate that.
All right. And counsel, have you both submitted your proposed jury instructions?
I have.
Mine should be today, Judge.
Okay. And again, I don't need a full text copy, just additional or different or any objections to the prosecutors.
Yeah, and I think Mr. Ziegler and I spoke about jury instructions, so there are issues that, well, let's just say issues, the instructions, the standard ones that we'd agreed on, those are submitted, at least Mr. Ziegler's from his behalf. So any additions that I need, I will submit those issues.
Okay. All right, Mr. Ziegler, any other issues that we need to address before we begin with jury selection on the morning of trial?
I don't think there's anything I need to address today, Your Honor. Obviously, there's some scheduling things that will bring to the court's attention as to when witnesses will be called. Nothing that needs to be addressed today, Your Honor.
Okay, Mr. Germer.
Nothing that needs to be addressed by way of trial. I'll simply indicate that the plea offer that was tendered in this matter was to murder two. All of the counts, including the habituals, would be dismissed. Mr. Galt is aware of that, and Mr. Galt has rejected that. So I wanted to make sure that was in the record and clear for the record.
Okay. Mr. Galt, do you have any questions about it? All right. And you are aware of the plea offer in this case? And it's your decision to decline to accept the plea offer?
Yeah.
Okay. All right, so we'll proceed with trial, beginning with jury selection on the morning of May 20th. Mr. Germerthy, are you going to be able to make arrangements so that Mr. Galt is dressed appropriately?
Yes, Mr. Galt already has some clothing. We've tried those on. He's indicated that one of the coat jackets might be a little too short, so we're going to navigate sizes and stuff, but he already has at least half a dozen of things right now with him, so we're just going to have the jail in Wexford County have him try them on and make sure.
Okay. All right, thank you. Then we'll proceed with trial.
My only question, judges, and I don't know the answer to this, since Mr. Galt is housed in Wexford County, but it's a Kalkaska matter, is he going to stay here for the duration of the trial, or will he be in Wexford?
I will bring him up personally that morning early, so he'll be here that morning. And then he will stay here through Friday. If it continues past that, he'll go back for the weekend and then come back up Tuesday morning.
Okay.
So any clothes that he has, you're gonna want to have here.
Okay.
If you have different changes of clothes. And I will work that out with, do you have the jail surgeon's email?
Over here?
Yeah.
Tilly.
Sergeant Mike Tilly.
Yep.
Yep. If you email with him, you can work out all that stuff because obviously they have to go through all that stuff.
So do you want me to bring that up to Calcasas from Wexford?
Yep, all that stuff you're gonna want here.
All right, we can do that. So I think that answers some of the logistic questions of where Mr. Gold is going to be. Thank you.
You know, the only issue I have with that is Calcasas County feeds peanut butter and jelly sandwiches for breakfast, lunch, and dinner. You know, I mean, I should be entitled to real food at least.
I don't have any control over how the jail operates, so that's up to the jail.
And I think the jail's gonna work something out there. You know, they were just whispering to me, but I can do that off the record and have that conversation to make sure Mr. Gold is. We're here for 10 days, 9 days, so I think Mr. Gold is right in having some adequate food if there's some issues, and I'll deal with it.
Okay. All right, okay, thank you. That's all for today then.
Thank you. Okay, that's fine. So they have an idea of what they're expecting. Okay, thank you, sir. All right, thank you. Thank you, Judge.
Mr. Elhart, which file are you here on?
All right, discovery matter of, right, this is 11:30.
I have at 11:30 is a motion for entry into the fall judgment. No, it's, oh, you're not listed on it. It's Kibbe versus Lane.
No, that's not me. I had discovery schedule 11:30 here.
I thought I saw him on the docket at 145, Judge. If you just see.
I also have 145.
Okay, I saw you at 145.
Thank you for controlling the document.
You're welcome.
I do see the 145.
I just figured what. Mr. Allen, I had to give him the
This all
check.
the time, Judge? I mean, does he do this all the time?
Absolutely. Well, Mr. Barnett was here last time, he goes, Mr. Mertz. Mr. Murthy's outside, let me go get my stuff done, because he's gonna jam you up, Judge.
No comment.
Okay, well,
I'll
the
let
other
you
one-
guys, I'll let you guys.
The other one's a 145 by Zoom, so I'll just turn that.
Yeah.
That matter has been resolved.
Okay, great. I think I did get a proposed judgment.
Yeah. But in the meantime, I've just watched Ziggy and learned.
I wish that were the case.
On the iPhone, can you tell me your name, please?
Sure.
Yeah.
You can unmute, please. Tell me your name, please. Can you tell me your name on the iPhone? Mr. Ziegler, I believe that's the end of our criminal docket.
Your Honor, we had passed Mr. Way's
Oh,
matter
that's
to
right.
give Mr. Travis.
Okay, can you check with Mr. Travis and see?
Judge, are you on the record?
Yes.
I'll wait a second.
I have one more case,
Okay.
or actually two more.
You're right.
Okay. Whoever's signing in on a Motorola device, can you unmute and tell me your name, please?
My name is Monty Bingham.
Can you tell me what case you're signing in on, sir?
One with Justin Lane and Liz Kibbe about a house in Calcasas County on 11301 School Road.
Okay, got it. Thank you.
He's trying to get in too, but it will not work for him.
All right, thank you. I'm just gonna mute you for the moment here. Okay, Mr. Popovich, are you able to hear me okay?
I am, Your Honor. Thank you. Nice to see you.
Okay, thank you. We're gonna go on the record in Kitty versus Justin Lane. This is file number 2414643. I do see Justin connected, but I don't see audio is not connected. And Mr. Popovich, you're representing Miss Kitty in this case, is that correct?
That's correct. And she and I spoke earlier. She had mentioned she was planning to be here, so I'm not sure if that's her on the Motorola.
No, that's not her. She's signed in under an iPhone, but her microphone is not connected.
Okay.
Whatever. It doesn't appear that she's able to hear me.
Okay, I'm on.
Oh, okay. Are you Miss Kibbe?
Yes, I am.
All right, thank you. I'm gonna try and communicate with Mr. Lane here. All right, whoever's joining us on the phone with the last four digits, 6272, can you tell me your name, please?
Yep, Justin Lane.
Okay, we have Mr. Lane connect now, so again, we'll go on the record in Kibbe versus Lane, file number 2414643. We have Mr. Popovich connected on behalf of Ms. Kibbe. Mr. Lane is connected by phone. Mr. Popovich, this is your motion today for entry of a default judgment. I did have an opportunity to review your motion prior to the hearing. Anything that you wanted to state for the record in support of that motion here today?
Yes, Your Honor, just briefly, I do recognize that the motion had a confusing reference in between paragraphs 4 and 5 stating request for default judgment to quiet title. If the court, for its reference, if you look back at the complaint we filed, it was for unjust enrichment. These parties are co-owners of a piece of real estate for which Mr. Lane has sold under land contract. Ms. Kibbe's not received any of the payments due under the land contract. So the complaint was for unjust enrichment. The relief sought under the motion is for $17,500. That would be half of her payment, half of the payments due under the land contract for which we believe she's due. With respect to the title of the property, it's held in such a way that it can't be partitioned, but we will inquire as to collection of the $17,500 at a later date with Mr. Lane, the traditional collection action, and take other actions as we're able to on behalf of Ms. Kibbe with respect to the title to the property. But I did want to clarify that bit of confusion. The motion is a fairly simplistic motion, but that would have confused me, and I look at that and I apologize for not deleting it prior to filing. But we are simply seeking a judgment for $17,500, which is half of the payments due under the land contract as referenced in the underlying complaint. Mr. Lane has not appeared. He's been defaulted, properly defaulted, and we're filing this motion. Mr. Lang, for clarity, has reached out to me at least once during the pendency of this action and advised that he felt that no money was owed to Ms. Kibbe, but he's never filed an appearance. He's never filed an answer, I should say. and he's never retained legal counsel to defend him in this case. So thank you, Your Honor. I appreciate your time this morning.
Thank you. Mr. Lane, were you able to hear all of that?
I was, yes, I was.
Okay.
So back in, can I say something real quick?
Yeah, for sure.
Okay, so back in April of 25th, 2022, I already paid Elizabeth Kibbe $13,500, and I did email it to Mr. Popovich, and I did email it to his secretary. So 129, I emailed this paper's notarized from the bank saying that if I don't pay it by 2022, so I pretty much already paid her off, but on 129, I emailed Mr. Popovich, and then I contacted him again on the 5th, and then I contacted, he was on medical leave, so Sealy, his representative or whatever, the front desk lady, I emailed her it too. So this paper right here says pretty much, I, Justin Lane, will be paying Elizabeth Kibbe $1,000 a month on the 8th and the 5th of each month until the full amount of $13,500 is paid off. This payment is for half the price of a home we own together at 1113 Lunch School Road, White Lake, Michigan. If payment is late, there will be a $25 late fee added to payment when paid in full. Payment for the home of $13,500 is made. Elizabeth Kibbe will sign her name off the deed. Final payment should be made by April 25th or 2022. And I got all the bank statements that I paid her. This was like,
Okay.
right, this was years ago. and the house ain't on a land contract. It's a renter. I have no documents for a land contract.
All right. Is there a reason why you didn't file anything in answer to the complaint in this case and submit those documents?
I did. I tried emailing them to the Popovich.
No, I mean in the court case, to the court.
I did not do that. No, you're right. No, I did not.
Okay, is there a reason why you didn't do that?
Yeah. No, I should have. You're right. Yeah, I should have.
All right, so here's the problem. Here's the problem, Mr. When you were served with the summons and complaint back in November, on the summons, it gives you instructions that if you want to contest the case, you've got to file your answer within 21 days. So when that doesn't happen, the other side gets a default against you, which means that from a legal standpoint, you can't contest the fact that you owe this money. Now, my suggestion is, if you want to get this default set aside or somehow challenge the case, you need to consult with an attorney, and you need to do that really, really quickly because you've
I'm going to consult.
You kind of sat on those, and so.
So the summons I was supposed to reply to right here, is that what you're saying?
Yeah, what you were served with, let's see. You were served on Wednesday, January 15th. So yeah, you had 21 days from that date to file an answer.
Okay, yeah, I guess I was confused on that part.
So, I mean, at this point, from a legal standpoint, you don't have a basis because you've been defaulted to contest that you owe this money, unless, again, you can hire an attorney. There's ways to try and contest that, but. Again,
yeah, that's what I'll have to do because this paper already paid her $13,500, and then 3 years later, she's trying to get $17,000.
Yeah.
So I guess you're right. So how would I go about that? You said get an attorney.
Yep.
Write this down.
That's all I can advise you to do is get an attorney to find out what your rights and options are at this point, given the status of the case.
Rights and options. Okay. So attorney, figure out what my rights and options are for this case.
Correct.
Okay. I just had to write it down real quick.
Sure. And to the merits of the motion, Mr. Popovitz, based on my review of the file, and under the court rule, given that you're seeking a sum certain that has been supported by the documentation in the complaint, I do find that you are entitled to a default judgment. And did you submit one with the motion?
Your Honor, I don't believe we did. I'll email that over to the clerk and apologize for that oversight. If I may also just have a moment to address Mr. Lang, just based on some of his comments, only to clarify a couple of things so he knows moving forward.
Did you want to do that on the record, or do you want me to put it in a breakout room?
No, I appreciate the offer, Your Honor. I just wanted for the record, Mr. Lang, when he advises the court of the contact he's had with me, I agree that he and I had some calls. He's also correct that I was on medical leave. I was unexpectedly out of the office from the 14th of February till about the 24th of March. But that being said, our office has no record of any emails from him, either myself or my assistant, Susie. So to the extent he's read into the record or read into today's proceeding documentation, those documents we've not seen. So that being said, per the ruling and per your Honor's statements concerning the matter in the motion, if agreeable with Your Honor, we'll email over a sum certain default judgment proposal to the clerk to place in front of you for signature.
Yeah, I'm just asking you to submit that under the 7-day rule, per court rule. And the court will sign that in due course.
Thank you, Your Honor. We'll process that today.
Okay. All right. Thank you. That's all for this hearing today. And
one more question real quick. Sorry.
Sure. No, go
one
ahead.
more question. I just want to make sure the email that I got for the Popovitch is right.
Okay.
It'd be GPOPOVITS at michigan-legal.com.
Well, that would potentially explain it. Both emails, Susie's and mine, would have the at be mich-legal.com.
Yep, that's what I got.
Not Michigan, MICH.
MICH. That's what I got. MICH.
Okay. Yeah. Try to send them again. I don't know. We'll just get the note. We'll get the proposed default under the 7-day rule, Your Honor, with the notice of entry.
I just know when I send an email out, normally if it don't go through, it'll say not an active email address.
Okay. All right. Thank you. That's all for this hearing today. All parties are free to disconnect at this time.
Thank you, Your Honor.
Thank you.
Thank you, Elizabeth. I'll be in touch.
Thank you.
And that's, excuse me, and that's where we will call it a day, ladies and gentlemen. Thank you for being here. Tomorrow is Judge Henry Anzalone. Yep, I can't believe this week has gone by so fast. Tomorrow is Judge Anzalone. So I will see you then. So for now, ta-ta and ciao-ciao. You have a wonderful, wonderful evening, and I'll catch you on the next one. Have a good one, everybody.